Thank you, Madam Chair, and I thank the witnesses for being here today. Before I get into the substance of this, I must point out that the title of the hearing today seems disingenuous to me. If my colleagues on the other side of the aisle want to be taken seriously in their oversight of the Trump administration's immigration and national security-related policies, then the least they can do is have the titles of their hearings accurately reflect the issue. But my colleagues have decided to ignore the realities surrounding the executive order entitled Protecting the Nation from Foreign Terrorist Entry into the United States, and instead continue to sow discord among the American people by merely the title of this hearing today. Of course, the 7 countries in the original January 2017 travel executive order were those countries specified by this Congress and the Obama administration as countries of particular concern for terrorism pursuant to the Visa Waiver Improvement and Terrorist Travel Prevention Act of 2015, a bill which the Democrats allowed to be considered on the House floor under suspension and which only garnered 19 votes in opposition. And as the United States Supreme Court noted about the subsequent presidential proclamation, quote, the text says nothing about religion, close quote, and, quote, the policy covers just 8% of the world's Muslim population, close quote. So if the point of the travel executive order was not to ban all persons of a particular religion from entering the United States, what was it? The point of it was exactly what the September 24, 2017 presidential proclamation stated in its title: enhancing vetting capabilities and processes for detecting attempted entry into the United States by terrorists or other public safety threats. It is ironic that my Democrat colleagues are holding this hearing less than 2 weeks after the 18th anniversary of the September 11th terrorist attacks, an attack in which foreign national terrorists exploited U.S. immigration law in order to gain access to the United States for the sole purpose of killing thousands of our citizens. Maybe we need a refresher on the fact that the September 11th terrorists submitted 23 visa applications to the United States government, of which 22 were approved. They were approved despite both blatant omissions and lies in the applications, and they were approved after background name checks were conducted. It was clear after 9/11 that our vetting and screening was insufficient. In the years since 2001, our vetting has remained insufficient enough that we issued immigration benefits to a number of individuals who were a national security risk. For instance, among others, we issued a student visa to a terrorist who settled in Texas and a fiancé visa to a terrorist who went to California. And just late last week, the Manhattan U.S. Attorney announced the indictment of a naturalized U.S. citizen originally from Lebanon on charges of being an agent of Hezbollah. He entered the United States in 2000 and was naturalized as a U.S. citizen in 2008 despite having joined Hezbollah in 1996 and receiving training before his entry, despite being an operative of Hezbollah's External Operations Unit, and despite receiving explosives trainings from Hezbollah in Lebanon in 2004 and 2005. It is obvious our vetting and screening was not sufficient. Today we sit in a hearing in which my colleagues intend to lambaste an administration for putting forth a policy that, at its core, was meant to increase immigration-related vetting. This president promised the American people he would do that, and he has followed through. Of course, no vetting is perfect, a fact which this administration recognizes. That's why Presidential Proclamation 9645 includes a requirement that, now annually, the Secretaries of DHS, in consultation with the Secretary of State, the Attorney General, and the Director of National Intelligence, update the President regarding procedures related to immigration screening and vetting, with the purpose of enhancing the safety and security of the United States. The initial executive order and subsequent proclamation were based on the President's power under Section 212F of the Immigration and Nationality Act, as well as the President's foreign policy powers vested by the Constitution. INI 212F states that whenever the President finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Presidents of both political parties have used 212F many times. Proclamation 9645 specified 8 countries subject to temporary travel restrictions due to inadequacies in the country's cooperation with the United States identity management and information sharing policies, as well as the terrorist presence within those countries. One of those countries, Chad, had their travel restrictions lifted just 7 months later after they improved their identity management and information sharing practices with the United States. Proof that the restrictions are temporary in nature. The travel restrictions for each country range from only restrictions on immigrant visas to only restrictions on certain non-immigrant visas to a mixture of both. The state of Hawaii sued to have the travel ban struck down, but in June 2018, the United States Supreme Court reversed a Ninth Circuit injunction finding that the plaintiffs were unlikely to prevail on their claim. Of course, I agree with those who have suggested, such as then Secretary of DHS John Kelly, that the implementation of the initial travel executive order should have been better. It was not rolled out well, communication among government partners was lacking, and there was confusion. Given the importance of the issue to our national security and to those affected, the administration simply should have done better. But only my Democrat colleagues would argue in opposition to heightened security on aliens who seek to enter the United States. President Trump promised the American people his administration would increase U.S. immigration vetting and screening capabilities. He issued an executive order to that effect, a revised executive order, and a presidential proclamation aimed at doing just that. He has been successful in getting the majority of the world's countries to allow us access to better information for the purposes of immigration vetting, and his actions have made us safer. For that, I'm grateful. I look forward to the witnesses' testimony today, and I yield back.